Welcome to the Thurston County Board of County Commissioners Superior Court update. It's Thursday, June 3rd, 2021. It's 1:03 p.m. My name is Ty Menzer, Chair of the Board. To my left is Vice Chair Commissioner Edwards. Commissioner Mejia is excused today. County Manager Ramiro Chavez to Commissioner Edwards' left. Clerk of the Board Amy Davis. And then on our Zoom we have Assistant County Manager Robin Campbell. We have Superior Court Judge Christine Schaller, our Superior Court Administrator, Pamela Hartman-Beyer. So we've got an hour slated. The public can follow along on our YouTube channel or through our conference line at 360-252-9020. The PIN is 1234, and the agenda is simply open monthly update with Superior Court on various issues touching both of our respective books of business. So should I start with Judge Schaller?
Well, first, I'm glad to be here today to stand in for Judge Price, who is out. I believe that oftentimes the Superior Court update focuses on a lot of the issues that are at our main campus. And so today I'm going to start by talking about issues that are going on at Family and Juvenile Court. I've been over here as the Chief Judge since February 1st, and Judge Lanise is the second judge here on rotation, and he's been here since mid-January. Starting on March 1st, we made some significant changes to our calendaring so that we could open up judicial time to hear trials. With COVID, the calendars were created in such a way that for social distancing and all those reasons that there was very little trial time. So we have quite a backlog of trials. So Judge Lanise and I are in court every single day. We're either hearing trials. We also hear the dependency work here at Family and Juvenile Court, which is extensive. And so we hear that every week as a regular motion calendar. We have a motion calendar for family law cases. Once every other week, we hear them in alternating weeks. And then Judge Lanise hears juvenile pretrial cases, and I hear our family recovery court. All the other time, we are in trial. And so it's extremely busy here, like I know it is everywhere else, but it's very busy, and we're starting to really get through trials. Part of the reason our backlog is not only COVID related, but it's also related to the repeal of non-parental custody cases. That was supposed to be effective January 1st. The governor extended the effective repeal to the end of the state of the emergency. And so we've been operating on June 30th as our deadline. And so we try non-parental custody cases almost every single week, either Judge Lanise or I, occasionally both, so that we can try and resolve all of those cases before the law is repealed. It's a really big deal. It's a lot of kids in our community that these cases impact. I'm started a trial this morning on that issue. And so that's impacted the way we prioritize trials. And so we haven't gotten to other type of trials because we've prioritized those non-parental custody cases. Our Safe Babies Court, which you know that we have been working on starting and are super excited about. We were ready in May to accept our first family into the program. And then our Safe Babies Court coordinator, Laura Vogel, was offered a position with the Administrative Office of the Courts, which was really an amazing opportunity for her. And so she left. And so we didn't take the first family, and we have the position posted again, and it closes in a week or so. The one good thing that has happened is, besides the fact that the program is ready, Laura did a tremendous amount of work, and so someone can just step into the position and really launch the program. But we received extended funding for the coordinator position that Laura held, and for an additional year. So we can actually find someone who might be interested in the position, because it's not just for a couple of months. And I would tell you that we have met through that program, countless people in the community and the community has been excited. Treatment providers, pediatricians, birth to 3, Head Start, all of these providers come together and meet about what this program is going to look like. And we've had incredible engagement from the community that we're really excited about. We are very thankful that we were able to submit to you our request for funding, and this is for the entire court, related to the COVID backlog. And we know that we certainly may not receive everything on that, but we were tried to be really thoughtful in the way that we put this together and look and target the best way that we can address the huge number of cases that we have outstanding, which are not just criminal cases. Those are probably what you think the most about, but civil cases, family law cases, termination cases, all of those cases, in addition to the outpouring that we are expecting of unlawful detainer cases. Although we're hopeful that the mediation program that is set up will be helpful with that, we do expect just a deluge of filings when the moratorium is lifted. We are also, as you know, we're very thankful that we have the Chandler Court facility because it has allowed us to run 2 criminal trials at a time. It's been very functional, and we would be in such a worse position if we did not have that. So we're really thankful that the funding was available for that facility and continuing hopefully for that facility as well. Also, just lastly on our COVID requests, we are hopeful that as things start to open up more, as we get more information from public health and other directives about social distancing and those requirements, that we will be even able to, of course, hear more cases. We still have the parameters of really small courtrooms, extremely small jury rooms, so it's not a magic fix, but we would have more capacity as some of those restrictions loosen up as well. And of course, once we get our 9th judge in November, that also will put another judicial officer into play. We have already been talking about what we see that person doing, not that person, not the new judge, but a judge who, because we would then have 9 people to divide the work among, that what this new position would look like. We're going to be sending a survey out to stakeholders, asking for some input where people see the need. And although I would anticipate that criminal lawyers are going to say we need the need in criminal court, and civil lawyers are going to say that the need is in civil court. But we do want to hear from people, and it'll be helpful as we try and identify the best way to use this position. And we anticipate that we could use it differently in the next couple of years than how we will use the position long term, specifically targeted at some of these backlog issues. Related to that, one of our requests continues to be a 5th courtroom at Family and Juvenile Court. And that would, well, I will tell you, it's completely necessary. Currently, we have 5 judicial officers at Family and Juvenile Court, 2 judges, 3 commissioners. One of the commissioners is here about 2/3 of the time and 1/3 of the time at the main campus hearing prelims. And we have a part-time commissioner 1 day a week who hears ITA hearings. And we don't have enough space we don't have enough courtrooms for how many judicial officers we have. So it's a very, very difficult situation. And so the 5th courtroom would be incredibly helpful. We are hopefully, I am like literally crossing my fingers as I'm talking to you, hoping that we'll be able to make a decision on our juvenile court administrator appointment in the next week. We do have an extended board of judges meeting this Friday. And so we're talking about a whole bunch of issues, including that. And we will be excited to announce that to everyone. We had 3 really good finalists. And so we're excited about the quality and the experience of the final 3 candidates, and are excited what that can bring to our juvenile department. And I think that I have addressed everything, Pam.
Judge, I just don't know if you want to share what our current masking for the public.
Thank you. So of course, we're using the forms that were provided by the county for masking. And we have a policy that allows our employees in our secure areas that if they have provided the documentation that is required and that's been verified, that they can remove their masks or not wear their masks in those secure areas. But any public or shared areas, they are still required to mask. So we're still masking in the courtroom. We're masking in all public areas of the courthouse. Also here at Family and Juvenile Court, when you come in through our employee entrance, we have people who enter there for clerk's office, our juvenile probation officers, and all those people who are in that juvenile department, all of our admin in this building, but also prosecutors go in there, defense go in there. So we are considering that it's not public, but it's a shared space. And so we're requiring people to be masked in that space as well. And that's one of our big topics, I think. I guess we'll see, but at our Board of Judges meeting on Friday, because we expect that the mask mandate, as Romero was talking about when he gave the presentation to the county, to the elected officials, it's going to continue to change. What happens on June 30th potentially, and we're trying to think that through as well, and what's going to work best in our public spaces and in our courtrooms. So that could change in the future, just like the county policy. And then one final thing. Yesterday, I was a part of a meeting and Romero was there for our pretrial improvement projects, APPR, that we are involved in. And Sheriff Snaza, Chief Jelsic, and Chief Almada were there and presented about the significant changes for law enforcement. I believe July 28th is the date that's in my mind as to when those go into effect, as it relates to the huge changing in police function at that time and the impact that it's having. We were discussing it because it impacts their office, impacts how their employees do their work. It impacts who gets arrested and all of these things, which ultimately impact pretrial. And one of the things that was discussed were, the significant number of people with mental illness who the law enforcement won't be engaging with, and the issue related to Involuntary Treatment Act cases, whether or not those could increase, whether or not they won't increase because law enforcement won't transport people, if there's any pushback on whether or not they should be transported. To me, in the back of my mind, I continue to think that we could have an increase in ITA proceedings, and we already have a tremendous number of those, based upon the changes to how law enforcement is to do their job and their caretaking functions, which is significantly different starting at the end of July. And so in the back of my mind, I've just been thinking about that. I think we have to plan for that as well from the court's perspective if we have an increase in hearings. So I think those are my updates. Anything else, Pam, that you think we missed?
I don't have anything else, but I think we're both available to answer any questions
Yes,
that the commissioners may have.
Can we go backwards, kind of? I know Commissioner Edwards and I are sitting on the board of the BHO, what used to be the BHO, BHASO, and we were talking about this law enforcement issue. Is this related to like the fact that what they described was kind of like a hole in the law? I mean, it's kind of like about when use of force could be used, but the law was not about mental health, but as the law would apply to mental health folks, it would create an ambiguity that law enforcement are not going to be comfortable using force on somebody that might need commitment. It seemed like the law had not contemplated that. It was really about other situations. Law enforcement were taking that law and applying it to how it might apply to a mentally ill person in an ITA situation and saying, it's not clear that we're allowed to do this, so we're not going to be doing it because it creates liability. And that suggested to me, if that's what we're talking about, that, and they were already talking, I believe, to state legislators about this kind of, if I call it a hole in the law and how it might be addressed. Or are we talking about something else?
Could I add something to that?
Yeah.
I think what I walked away from on that was that use of force was boiled down to any touching almost.
In any situation.
In any
context.
situation where if the person didn't voluntarily get in the car, for example, they couldn't kind of even assist him into the car because that became use of force under that new proposal. So
I think it's a cumulative effect of what I believe, Your Honor, if I may. It was 11 new pieces of legislation that is, and I have a copy for you, a nice reading that will be distributed after this meeting. And all that is encompassing related to this. The conversation yesterday was the dispatcher, a 911 dispatcher, will probably be in the position to make the call whether law enforcement is called or they have to refer to other professionals.
Crisis response.
Crisis result. So the decision-making process on that begins, I believe, based on the description that I heard yesterday at that level, at that point. The 911 dispatcher will be in the position to make that call whether law enforcement is dispatched to respond to this particular instance or other professionals, perhaps. Was that your understanding, Your Honor?
Well, I agree with actually what everyone just said, because I think all of that is entailed in what was described yesterday. And I think the best example was Chief Jelsic gave us a specific example of something that happened over the Memorial Day weekend. A man from King County was diverted down to St. Pete's on an ITA. They released him. They found he didn't meet criteria. He didn't meet criteria, so he was released into our county. Nowhere to go, no money, of course, all of those things. He was walking in downtown Olympia carrying a knife and a machete. So law enforcement started getting calls. He went into a subway station, ordered a subway store, and ordered a sandwich, and then walked off without paying for it. But the employee saw that he had a machete, so they didn't try and follow him or talk to him. They contacted law enforcement. Law enforcement kind of kept eyes on him, didn't engage with him for a couple of days. On Monday, this person went into a Safeway store and stole food. But a Safeway store employee confronted the gentleman before he could leave. He brandished his machete. So then law enforcement's called again, and this person is obviously very mentally ill. So the police are trying to use these new techniques of no hands-on, trying to get him to come with them because now they have PC for robbery too on this mentally ill person who they didn't feel like they could intervene with because he had the machete, and they knew that there was no way that he was going to be easily redirected. He started walking towards the skate park, and he was very close to entering the skate park where there were 20 plus kids. He had his machete up, and so finally they used the beanbag gun because they'd been trying, come with us, come get in the car, that whole thing, and it didn't work. It was 4 police cars. And so that was the scenario that the chief was talking about. Mentally ill person, even if they could have at the very beginning when it was a theft 3 that they wouldn't have arrested him on to potentially try and take him back to St. Pete's, but they knew he wouldn't go willingly. That law enforcement is worried too about this hole, as I think is what Commissioner Menzer said. It's huge about, I think, law enforcement's ability to address real safety issues because their caretaking functions have been significantly limited. Well, the chiefs said that it's gone. I don't know if it's gone, but it's significantly limited. And so these people who would have gone to jail and gone potentially certainly aren't going to jail, which on the one hand is a good thing. But our mental health system is not set up to deal with the number of people that we're going to have who need some sort of service. And I do believe that some portion of those people are going to at least end up in ITA facilities. And so, I don't know, it's very concerning.
And I called it a hole because when I asked the BHO, I said, the guys there, I said, was it that the legislature debated this and decided that they wanted it to apply, or was it just didn't, it wasn't really something they talked about? And their impression was that this situation was not debated at the legislative level. So that leaves open the opportunity, hopefully, to work with the legislators to see that, hey, you missed a kind of a situation here that needs some guidance and some refinement. I mean, some of these laws I think will be good, but they're going to need to be refined.
And some funding.
Right.
Well, I mean, that's the other thing. Everything is completely underfunded. We don't have enough, from the way they described it. I'm not going to pretend I'm an expert, but enough funding to fund the other agencies or stakeholders who would need to work within this process to make it successful. If we have nowhere to funnel people with mental illness or substance abuse issues, because they're not going to be having contact with law enforcement any longer, it's going to be difficult.
Yep.
And there is a significant amount of unfunded mandates that is going to be coming to local jurisdictions as well. So,
Yes.
Did the chief from Lacey say anything about would the officers be able to help? I think they're hiring 5 treatment type people, if I remember right, to go out and intervene. But how is that going to work if the police officers are still not able to do hands-on?
navigators, I think they were navigators.
Are they treated as law enforcement if they're hired by law enforcement?
Yeah, that's-
I don't know.
With behavioral health degrees?
Yeah, I don't know, but I think the same model as the city of Olympia really has some navigators.
Mhm.
That provides the level of support. And I think they were talking about mirroring the same type of a navigator program the city of Olympia is implementing. But I think that's what you're talking about, Commissioner.
Just wondering how it's going to work.
But I would say that all 3, Sheriff Snaza and the 2 chiefs are all very clearly concerned about the impact on the community. I mean, they can implement whatever they're required to implement,
Right.
but they're very concerned. And I asked them whether or not they're concerned about retaining or recruiting law enforcement officers, and they said that they are concerned about both. So I just think that as this is rolled out, there are going to be a lot of issues, and like Romero said, a lot of unfunded things which are necessary to potentially make this successful.
Judge, the scenario you laid out there about the guy with the machete and headed towards the playground with the kids and such, I mean, in essence, they've almost limited their ability to intervene until the point they have to shoot somebody.
Well, that is what they said too,
Yeah.
which is, that is what they said.
And also there's another piece of legislation that now they are required to report on other fellow officers, any type of report and intervene. I believe that's another piece of legislation if a fellow officer is conducting himself or herself in a different way. So
I have to
George
say,
Floyd response.
so that particular part of it doesn't bother me. I mean, I want officers to do the right thing all the time.
But I think the conversation yesterday was when is a multi-jurisdictional response.
Oh.
And how they're gonna be reporting against the city of Olympia Police Department versus the Sheriff's Office, so
Oh,
it
yeah.
becomes a lot more
That'll be interesting.
robust.
And they were also
conversation.
discussing the fact that they have different procedures and protocols.
Yeah.
They're trying to develop the same ones now, specifically to address that issue. But they were then also talking about how each union has to okay every change or every addition, and they don't know that they can uniformly get that accomplished.
By
Right.
July 25th.
Yeah. And the other piece of that is what works in downtown Olympia where backup is readily available doesn't always apply out in rural America where officers by themselves.
Yes. So I think there will be an impact on the criminal justice system. I think it's way too early to tell what that's going to look like as it relates to criminal cases and people in the jail, although I think it's anticipated that that will reduce the number of arrests.
Judge, these guys may not have the same interests that I have, but I was wondering if you could talk a little more about the non-parental custody law and exactly what the considerations are that you're, like what does the repeal really mean and why are you prioritizing those cases in that way?
Sure. So the law completely goes away, but if someone still has a non-parental custody decree, it is still valid. And so it's not like the decrees, the final orders are repealed. They're still valid. If there need to be changes to those in the future, that would have to go through the minor guardianship procedure, which was what was enacted at the same time that the law was repealed. And it's different and has a whole bunch of unfunded mandates in it. But, and we already have that process going because that law still did start on January 1st. And there were no new filings of non-parental custody cases starting January 1st. But we're prioritizing those cases so that cases that can get to a final order in a non-parental custody case can do that before the law was repealed. As soon as the repeal was passed, we ran a search for all of our open cases. We set hearings in every open case so we could determine the status, got cases dismissed that should be dismissed, got cases set for settlement conferences and trials that should be set for settlement conference and trial. And so, and the reason they have priority is because we can't do anything after what we anticipate could potentially be the end of the emergency state of Washington as being the end of June.
And what was the policy thinking behind that repeal? I wasn't really tracking that whole.
It was the implementation of the Guardianship for Minors Act, which has a slightly different standard. It also requires the appointment for parents.
Okay, I was trying to figure out how these connected and, okay, I got it.
Yes.
Okay, I'm with you now. The repeal.
Okay.
The repeal, I mean, Pam's always talking to us about the Guardianship Act piece.
Yes.
I wasn't sort of thinking about that came within a corresponding repeal of this old, okay.
And part of the reason that I believe that the governor extended the repeal was because we basically knew at the last minute that we had 6 months to try and deal with all of the non-parental custody cases. And with COVID, it complicated that, although we still couldn't have done it in 6 months. So now we've had essentially a year to try and get to those cases. And there are a lot of them.
Yep, okay. Any more questions?
How are we doing on juveniles in custody? Do you have any idea what we're at, numbers?
So we have, I would say that the average has probably been, I'm guessing like around 5 or 6. Sometimes that's slightly higher. We've been under 10 all year. We've been down to 1 at one point. The kids who ultimately end up in detention are kids who are here on really serious charges, a violent offense. And I mean, sex offenses are violent, but sex offenses specifically. And so the detention numbers have been even lower than they were previously prior to COVID.
Okay.
Good. I know that you guys have a meeting kind of, or when I say you guys, like, I'm not sure who will be attending, Judge Price or with the Bar Association representatives, leadership. They had invited me to that meeting, just heads up, and because some of the requests, what I was told was that they're going to be wanting to explore ways of dealing with the civil case backlog, because that might, we're hearing all of it, because it's true that the board's hearing a lot about the criminal side, as you alluded to earlier, Judge. And there might be some other opportunities because of the different considerations of civil cases, not having the security of the transporting and the sheriff and, you know, holding defendants and stuff. And there might be ways to do civil backlog stuff that wouldn't be possible with criminal. And some of that might involve, you know, relief money and commissioners' decisions to fund those ideas. So they invited me to sit in and kind of hear what their thoughts were and kind of gauge what the court's reaction to those ideas might be. Just giving you a heads up, and if you wanted to, if you had any, have you been engaged with this group, or is this they're gonna be presenting stuff to you for the first time?
So there's, I think that there has been some discord from this civil bar, that they have not agreed with all of the policies and procedures that we adopted during COVID, the way we manage the civil motion calendars, the way that we haven't done civil trials, although we've really been open for bench trials almost the whole time, but certainly we have not done civil jury trials. And when we determined it was safe to reinstitute jury trials, we indicated we couldn't do civil jury trials because we have to prioritize people who are in jail and get those matters tried. And so there have been communications. I think there's been some difficulties in communication sometimes and different perceptions. But the meeting is truly to try and open a dialogue so that we can talk about different solutions. Our backlog is big, and it's, like I said, it's not just the criminal cases, and yet we still do have to prioritize cases based on constitutional issues and things like that. But I think it's great if you want to come to the meeting and learn more about that. Although we don't have the security issues in civil trials, a jury trial is a jury trial. We have space issues. Those are our issues. Not that security isn't an issue in criminal trials, but even civil trials, it's do we have enough space to run a civil jury trial and run our criminal jury trials? And we hope so. I mean, that is what we want. We want to get to those cases as well.
Commissioner,
Yeah, go ahead, ma'am.
just if I can briefly, Mr. Kessler, who I think is heading that planning for the bar, did notify me that he invited you. I think the judges were just going to talk about that a little bit at a brief meeting. I think when we initially set up this at least first session, the idea was really to have mutual respect bilateral meeting and to have a kind of a brainstorming session. And so I guess I would encourage you possibly to come in the future, but that first meeting may not be the best opportunity for that. So maybe we can have further discussions after the judges have an opportunity to have further discussions with Mr. Kessler.
Okay, all right. Well, and you know, Robin's here, and I bring this up kind of in this context because like one of the ideas was, you know, when it comes to space, if you've got a judge, but you just don't really have the space to have I guess there was concern about jury deliberations, and so the juries can be, you know, if one trial is going on in Chandler, then they need space for juries to deliberate. Could another, you know, jury potentially have space to deliberate? And, you know, he pointed out that, you know, Mason County, I guess, had done a civil trial in an empty office building or something, and you know, Hotel RL's got a ballroom or whatever. There may be space that would be COVID money type stuff, you know, that we could use because it's kind of extension of what we're trying to do at Chandler Court. But you might rent a space for you know, for a short term to get a big civil trial done with plenty of space for all. If it's just a space, you know, obviously there's a lot of things, a lot of pieces to all this. But I know that there's opportunities we have when it relates to a COVID-related need versus other types of needs. So that'd be something that we'd have to run through you know, obviously the board and our budget folks and you know, the finance folks too. So, but I just wanted to hear those ideas and that, and well, you'll hear them, I guess. I heard, they were talking about how to handle these unlawful detainers, in some other way that to keep them from kind of clogging through all of your other counters that you're trying to sift through. If that moratorium is lifted and you do get that deluge that Judge Schaller mentioned. Okay, well, let me know if you feel like that there's a substantive reason for me not to attend. And I can check back in with TCBA to let them know that I'll engage in some other way or at some other time.
I will follow up. Thank you.
Okay. Anything, Ramiro? Okay. That was about it for my list based on what you guys ticked through. So
We're good?
I guess we're good.
Okay,
Thank you.
thank you all.
Yeah, thank you.
Good to see you. Take care.
Tough job.